Thank you for coming back or for joining us if you have not been here before. So just again, to welcome you to a series of sessions this afternoon on generative and AI and copyright that is sponsored by the MIT Schwarzman College of Computing. I'll start by introducing myself, and then I'll introduce Claire Schneider momentarily. But I'm a professor in the history department here at MIT, and that usually I follow that by saying, yes, you can major in history at MIT. And I teach and publish in the field of 20th century US legal history, and teach students about questions sort of like this. Full disclosure, I am not a lawyer. Although for years I have taught many MIT students who have gone on to become lawyers and can advise you. I always say I can talk you into law school or out of law school, but you have to tell me which one you want. And one thing I also wanted to just share with everyone in the community here, if you are looking for a lawyer, I also like to alert people, particularly students, or really just students, to the MIT BU Student Innovation Law Clinic. This is a free and confidential legal service for MIT students, undergrad or grad, who are seeking or may not even know that they should be seeking legal assistance related to their research advocacy or creative projects. And so if you are a student or know a student who would benefit from this, I'm happy to give you information about that group. What I'm going to do before Claire starts is just give a brief sketch of some of the range of scholarly views around some of the questions that we were discussing with Umair just in the previous hour. And one of the remarkable things about the scholarly approaches to generative AI and copyright is there's actually one thing that pretty much everyone agrees on in the legal scholarship world, which is that the existing copyright regime is not really a good fit for this new emerging technology. But that's about where the consensus breaks down. And beyond that, scholars who may themselves not be sort of practicing attorneys defending either authors or AI companies, but scholars thinking kind of more conceptually about this, differ in terms of whether that means the technology needs to be more rigorously regulated to bring it into line with the existing copyright regime, or that the copyright regime needs to be reformed in order to accommodate the new technology. And this is some version of the chicken and egg, or if you remember the old Reese's peanut butter cup commercial, you got your peanut butter in my chocolate. It's obviously, there will be a series of both of these unfolding over the next few years as the law changes and as the technology continues to evolve and also to be subject to regulation, both in the United States and in other jurisdictions like the UK or the EU. But just to give you a sense of it, one of the first, there are those who really feel that copyright is, in fact, actually the thing to defend and renew and using the law to bring the technology into alignment with it. And who do really feel that the task is basically to sort of accelerate and expand regulation to meet the new technology. A good place to look for this is in a piece in an article called, in a journal called Issues in Science and Technology. This is published by the National Academy of Sciences by Kate Crawford, a professor at USC and the author of The Atlas of AI, an excellent book, and her co-author, NYU law professor Jason Schultz. Who together sort of reflect on the ways that generative AI has, as they put it, been driving copyright into a crisis. And just to briefly quote from their work, "It may be time to develop concepts of intellectual property with a stronger focus on equity and creativity, as opposed to economic incentives for media corporations. We are seeing, we meaning the authors, are seeing early prototypes emerge from the recent collective bargaining agreements for writers, actors, and directors, many of whom lack copyrights, but are nonetheless at the creative core of filmmaking. The lessons we learn from them could set a powerful precedent for how to pluralize intellectual property. Making a better world will require deeper philosophical engagement with what it is to create, who has a say in how creations can be used, and who should profit." Now, a second, almost sort of very different sort of approach is coming from people who have argued in some ways that the copyright regime is not only a bad fit for this new technology, but maybe has been broken for a very long time. And that have been seeking to dismantle it, jettison it, or develop alternatives to it, whether they're coming from worlds of open source software, open publishing, open access worlds more generally. One really great place to look for this is an essay published in the journal Science by the law professor Pamela Samuelson from the University of California at Berkeley, who has really sort of been at the forefront of sort of arguing against copyright for a very long time. And so in some ways is sort of adapting her argument against copyright to the new technology of generative AI itself. And argues that in the end, this task requires balancing the legitimate interests of copyright owners to prevent misappropriations of their works that undermine incentives to create, with the legitimate interests of developers of innovative technologies and follow-on creators who need some breathing space in which they too can innovate. And so as we talked about in the previous session, trying to find that win-win for both creators and sort of AI innovators at the same time is really a high-stakes task these days. One place that I personally and many in the MIT community have looked to this is from our past engagement with an organization called Creative Commons. Creative Commons is an international nonprofit that exists to build a network for the open sharing of knowledge and culture. In many ways emerges from the MIT community and key players here. And in recent years has been advocating the creation and adoption of preference signals, ways that creators can signal to large language model developers the creator's preference for how their material is or isn't used. So just as when you would publish a work and maybe have a Creative Commons license on it, CC, CC BY, et cetera, there may emerge sort of from the community sort of preference signals that you could use as an author to communicate whether you wish your model, wish your materials to be trained with AI, wish them not to be, or trained by AI or ingested by AI, et cetera. And they have also been arguing for a broader suite of communication tools. And these may or may not necessarily be legally enforceable mechanisms, right? What they aim instead is to, as Creative Commons puts it, is to define a new vocabulary and establish new norms for sharing and reuse in the world of generative AI. And so as we look forward from this afternoon, I think that kind of work, sort of thoughtful creation, is what is going to be necessary to get us to the kind of next phase past this moment where scholars, creatives, and in fact many large language model developers themselves agree that the existing copyright regime is not a good fit for the technology as it exists. Now, what does all this mean, at MIT? Right, and so we're very lucky to have with us today a member of MIT's Office of General Counsel, and we're particularly lucky to have her today. As you can imagine, lawyers are very busy these days, reading the news and responding to it. So we appreciate Claire taking some time to join us here. Claire Superfine Schneider is a member. She's counsel to the Massachusetts Institute of Technology. She's been with the OGC since September of 2018. And her areas of focus at MIT include intellectual property, sponsored research, conflict of interest, entrepreneurial activities, and academic and business transactions. And for some time now, maybe since around 2023, she has been sort of part of groups of people at MIT who have been helping the community understand how generative AI is changing the way that we teach, learn, and research at MIT. She is a trained attorney with a degree from the Boston University School of Law and with previous years of experience before MIT in private practice at Mintz Levin and Wilmer Harrell. And so with that, I'll turn it over to Claire.
Thank you so much, Chris. And I wish that I had had you as a history professor so you could have talked me out of law school, but that ship has sailed, yes. And I know this is a small group, so tell me if the microphone is too loud and I will adjust it. So I'm going to do a bit of internal marketing since it's such a small group and just ask who in this audience has had occasion some might say for bad, but I would say for good, to interact with the General Counsel's office. Chris knows us well. We have one other taker. Okay, so I just want to give a very, very brief overview of who we are and what we do at the Institute. So, of course, as Chris said, I am an attorney. Myself and 10 other counsel are in our General Counsel's office, and then we also have a Deputy General Counsel and the Vice President and General Counsel, Mark DiVincenzo. We all represent the Institute first and foremost, but it's obviously more complicated than that because there are many stakeholders within the Institute, right? So we often are working for and with groups of stakeholders, and part of our job is to figure out how those interests are aligned with the interests of MIT so that we can be sure that we are always representing MIT. We do a variety of things. We give counsel, we give advice, we defend the Institute in litigation, we represent the Institute in the rare instances when we're on the other side of the V in litigation. We advise on transactions, we advise on policy issues, and we generally act as thought partners to other senior leaders on campus, to administrators, to faculty, and also to graduate students and other students. As Chris noted, and I'm so glad you called out the BU Law MIT Law Clinic, because it's a great resource for our students, because we in the OGC can't represent students individually, whether they're undergrad or grad students. But I find in my practice, personally, that I spend a lot of time talking to students, especially about intellectual property and entrepreneurial activities. And as Chris said, my focus really is primarily intellectual property. I do not take part in actually protecting inventions on campus. So, our technology licensing office does that, and I work closely with them at times and advise them. But mostly I'm thinking about intellectual property in terms of big transactions, technology licensing, IP terms that we are granting to our industry sponsors. So many of you may work on, or as PIs may have, industry-sponsored research agreements. And in exchange for funding research, we permit the company to elect to exercise rights to intellectual property developed under those sponsored research agreements. So there's lots of ways in which IP sort of touches the day in and day out functions of MIT. But as Chris alluded to, there's also these sort of sea shifts that happen that also touch on IP. In this case, mostly copyright, but there are patent questions that surround generative AI too. And so I have really had the good fortune of being at MIT during this sea shift, because obviously it is fascinating. I did want to sort of ask, the audience, because for me, generative AI, for many of you who are engineers and scientists, this is not all that new. Of course, there's been significant leaps in the past few years. I actually went to Dartmouth as an undergrad, and Dartmouth is always touting the fact that they had the first artificial intelligence conference back in the 50s, or that's what they say. They lay claim to that, whether or not it's true. So of course, I am aware and have been for some time that researchers and scientists have been working on this. But I would say from a legal perspective and the tentacles that generative AI has had in my world and at MIT as a whole has really, as Chris said, happened in the past few years. I think since early winter, in 2023. And it's now pervasive. It's a real zeitgeist, and it's changing kind of all aspects of my practice, and I think others like me. So I wanted to start by, before we get a little bit more deeply into the precise topic today of data and content generators and creators at MIT, I wanted to kind of give a broad swath, or almost a list, of all the different places and community members on campus that we're trying to track when we think about ways in which generative AI issues are affecting stakeholders at MIT. So we've been loosely, and as we go on, I don't know if we'll wait till Q&A or feel free to raise your hand now, but we're starting to collect this information. You wouldn't necessarily be able to go to MIT, the MIT website and find a lot of this written down, but we are starting to think about it. And we've been breaking these categories into 3 groups. So we're thinking about community members, obviously, who use generative AI tools. We're thinking about MIT community members who generate models, so AI systems. And then, of course, most of the MIT community who is generating content that can be used by both MIT community members to train models during research efforts, or by third parties that can use that content to train third-party models by virtue of the fact that we have an open campus and the goal of fundamental research is to publish, right? So, in fact, I don't know if any of you know this, maybe some of you do, that actually I think it's section 14.1 or something like that of P&P is our open research campus policy. And indeed, all research on campus must be open and must be published. And if it's not intended to be, there is a special escalation process that goes all the way up to the vice president for research. Of course, that excludes Lincoln Lab, which has its own rules, and much of what Lincoln does is, of course, not published. So this is really fundamental, to who MIT is. And I think, Chris and I will both touch on this a little bit more later. But that's when we think of those 3 categories. That's kind of what we're trying to track. And when I say track, I mean issues, concerns, legal rules or regulations, and then downstream consequences or exposure from taking one position or taking another position. That's, and then the type of guidance we need to provide to MIT community members. That's what I say when I mean sort of keeping track of all of these different categories. So with respect to the first one, which is kind of the easiest and the category in which I think you'll find most of our peers, including MIT, do have some guidance out already, it's using tools, right? So how to use them responsibly. Should you be downloading the open source version of ChatGPT, or should you be using the one that we have a license to under an enterprise license agreement? Do you have the right permissions in place to be using tools for certain projects? So, of course, you all, and I assume mostly researchers in this room, though correct me, are using tools for research purposes. But remember, we have a lot of other folks, in HR or admissions who might want to use these tools. And that's a very different story, right? We have to think about what data is being used and inputted into these tools in terms of sensitivity, et cetera. But back to the researcher side, we also have to be giving guidance to researchers who are using third-party tools in terms of using and inputting unpublished research results, right? Does that constitute a public disclosure under the Patent and Trademark Office's rules, such that you might be limited in the patent protection that you could get from subsequent outputs or inventions after inputting that data? So these are all items that we are trying to think through and provide guidance about. But those are a little bit simpler, and I think that we all kind of generally understand the issues that we need to think about. The second category is, for the developers of models. And I think, traditionally, we don't give a lot of structure and scaffolding, nor I think we should, necessarily, to PIs and researchers when they are putting together their grant proposals, scopes of work under industry-sponsored research agreements, and thinking through the research that they want to pursue. That has never been part of the MIT, core. But as we think about models that may have risk associated with them and may be regulated, and when we think about the data going into those models that also may be associated with risk and have potential, legal ramifications of using data in one way or another. We're starting to try to get our arms around that and thinking about what kind of guidance can we give researchers as they are putting together research projects. And obviously, this is early stages. There's a lot of conversations happening among and between research administrators, DLCIs, and faculty to think through this. But it really needs to stem from how we think about when and where this model will be released and accessible outside of MIT. And again, as I said before, traditionally, models are publicly released. It is my understanding that for publication purposes and, for certain journals, there are requirements about releasing parts, at least, of algorithms and data sets, et cetera, for replicability and transparency, et cetera. There's also rules under certain federal awards that require data to be promptly released and easily accessible. And we are trying to think through sort of, are there guideposts that need to be considered when doing this? For instance, there are regulations that have started to be developed. There is a EU AI Act, which many of you may be aware of, that has officially come into force. The EU is very frequently ahead of the US in terms of broad and sweeping and detailed regulation. That happened with GDPR and data privacy some years ago as well. In America, of course, the Biden administration put out their executive order on AI that addressed some of these topics in October 2023. That order will probably be revoked under the Trump administration. But regardless, we can assume that there will be regulations that will apply to AI systems. And I keep using that word, AI systems. It might not be something that rolls off the tongue for all of you, but that is because it was defined as such in the Biden executive order, so trying to keep some of the wording the same. We can assume that these models will be regulated in some way, shape, or form, even if they are used just for research purposes or developed in the context of research. And that is really, that's different. And when Chris alluded to before, sort of the traditional IP rules not necessarily fitting with generative AI, I think this is a little bit similar in the sort of regulatory space, because previously, this is a good analogy, and you may know this, export control rules, I won't say they don't apply, but they're less of a thing for MIT because everything we do falls under the fundamental research exception. And under that fundamental research exemption under the export control rules, we don't have to worry about getting certain licenses from the government to share certain otherwise sensitive technology with non-US persons on our campus, for instance. That's not true for companies that are not operating under the fundamental research exemption. Caveat to that is that those rules under the Trump administration, we could see some of that change too, which would be really unfortunate. But the way this relates to the models is that I think historically the thought was if you wrote software code and you put it on GitHub and you slapped a MIT Open Source Institute approved license on it, you didn't have to really do much more than that. Now the thinking is if there is a model that perhaps was trained with very, very large data sets or with high compute power or otherwise has dual use capabilities or falls in the number of other buckets that the EU AI Act references as being potentially high risk, that we have to be, and I mean we, MIT as an institute, have to be more thoughtful about who might pick that model up and run with it and use it for purposes that perhaps were unintended or for which we now somehow are going to be, I don't want to use the word responsible lightly, but, responsible for in some way, shape, or form, whether that's legal responsibility or reputational or otherwise. So we're trying to get our arms around that. I wrote it down here, it might be interesting. The EU AI Act thinks about sort of various levels of models in terms of risk categories. You may have seen this. There's high risk, medium risk, low risk, and then kind of like no risk. You can do whatever you want. And there's a lot of reporting obligations and restrictions for high risk models. And those are models that at least the EU would define as, obviously I noted before, correlated to compute power, dual use capabilities, also the capability to be used for purposes that are judged to be functions that could result in high-risk outcomes if performed improperly. Well, that's quite broad, right? Or whose output serves as a basis for decisions or actions that have a legal or significant effect on an individual or community. So you could imagine law enforcement. You could imagine hiring decisions, admissions decisions, et cetera. But you could also imagine a model, being used for a purpose that was otherwise not intended by researchers at MIT, but shared with collaborators and research sponsors. So these are all, areas. It's a little bit off topic from what we're talking about today, but it's all connected. And one of the most precise ways it's connected is that the EU AI Act requires that for all high-risk and medium-risk models, and this includes models being developed at research institutions, that there is traceability of the data that is ingested and used to create the models, and that all the appropriate consents and permissions have been gotten for the data that's being used. That is not something necessarily that we currently bake in to our research projects. Although we do have many researchers on campus who are dutifully and diligently working with the libraries and other stewards of content that we'll talk about in a moment to try to access data for training purposes in permissible ways. So I think that now when we talk about, the third topic, the third category that I was mentioning before, that's really the focus of today's talk, which are data and content creators and generators, we really think about sort of a few different buckets. We think about researchers who are accessing other MIT content for their own research purposes. And we think about researchers who are accessing third-party content for research purposes. And then we also think about all the researchers who make their own content available, perhaps as part of a journal or other scholarly publication, and now want to have a voice or a say, which is very appropriate, into how that content is going to be used moving forward. And the libraries and open learning, Chris can talk to us more about open learning, are two of our biggest stewards of content that MIT either owns, licenses, or otherwise houses, for lack of a better word, at MIT. And those offices on campus really are trying to think very thoughtfully about how to continue to give researchers the access they need under the appropriate permissions, preserve the openness of content, and encourage scholars to continue to embrace the value of that openness, while at the same time acknowledging that sometimes this content is being used either for purposes that are not aligned with that author or content generator's principles or values, or in a way that they're just not aware of, which of course takes away some autonomy and makes it a little less likely, perhaps subconsciously, to want to make things available and open in the future. I think there are a very, and those categories that I just named, of course, there's overlap, right? So you could be a researcher training a model who is desperate to access content from a third-party publisher through an agreement with the libraries, let's just say, and that third-party publisher could be pushing back on the libraries about giving access to that data for training purposes, and the researcher could be very frustrated. On the other hand, that researcher could have published a book, let's just say with the MIT Press, and could now be being asked to opt in to licensing that book to OpenAI or Google to train their commercial product. And that researcher could have a very different perspective on whether and to what extent to allow that access. I also think there's a really big difference in perspectives, at MIT in terms of if we don't make our content available and open to anybody to train models, those models and the public will suffer, right? Because we at MIT, you at MIT, have the best science, right? So we want the best science to go into training. Others feel that if we have no control over how content is used for training, especially outside of MIT, we will be disrupting the way that attribution has worked for, science and scholarly advancement for decades, if not centuries. So I think, and I want to be mindful of time here, I think one of the big items that we're thinking about in terms of providing guidance is also education. I think there are a lot of particularly grad students and other researchers who are very used to culturally simply making things available, whether it's software on GitHub or other content on whatever lab website they have or et cetera, sharing it very freely because it's part of our culture. So I think part of the guidance is going to be around educating and talking about sort of what choices are available if there are choices, and what do certain things mean when you take path A versus path B. And then I really quickly just wanted to touch on another group of stakeholders that I briefly mentioned before, and those are our in-house publishing entities, so to speak, and that includes the MIT Press, the MIT Tech Review, and the Sloan Management Review. And those entities, and for those of you who don't know, the MIT Tech Review is separate from MIT. It's an affiliate. It's a wholly owned subsidiary, but they are not, part of the educational research institution bubble. But MIT Press is. They're just like any other DLCI. And that is really fascinating because their interests are not always perfectly aligned, right, with complete openness for research purposes. And they, along with the Tech Review and Sloan Management Review to a certain extent, see an existential crisis in terms of science, journalism, and scholarly book publishing that I think is those concerns are very real and very valid. So we are also trying to be mindful of those interests while thinking holistically, which kind of gets me back to my first point about how working at MIT as a lawyer is challenging and fascinating because MIT as a client is not as simple as one might think. So I think Chris, should I stop there and go to questions? Thank you.
So I might just kick us off with maybe one or two, but then I'll move very quickly to the Q&A for the audience. Thank you. I think that we touched on this sort of question of open, and maybe I'll come back to that in a minute. But let me talk actually a little bit from where SERC kind of fits with this. So, social and ethical responsibilities of computing, as I mentioned in the first session, exist to foster what they call, quote, responsible habits of mind and action for those who deploy computing technologies. And I think that you've kind of hit on some very concrete moments where, there may never be bright line guidance that's going to come from your office. But what, in your view, what might responsible habits of mind and action look like? Both, what advice, might you give to MIT students or those of us who are teaching MIT students to kind of foster those responsible habits?
So I think, is this on?
Yep.
I think that's a great question. So I have a few different thoughts about this, and I have, spent a lot of time thinking about this because I do think I think about MIT as being a very open kingdom, but then there's all these gates, and there's sort of checks at all of these gates where technology leaves. And once it leaves, you can never take it back, right? So I think there is something to be said in the context of wanting to make research open so that researchers can build upon each other's work, advance knowledge, and also for science sake and for curiosity. There is something to be said for balancing that and taking a breath, right? And being thoughtful about potential downstream uses of technology and whether there are ways to, you used the term before, signaling with the Creative Commons. I think, you can't have a lot of control, but can you signal? And can you put up some gates that, where you have to walk through them before you leave the MIT kingdom? And one of those, this is a great example. This happened with the CRISPR technology that, was developed by MIT and Broad and Harvard. And I don't know how many of you know this, but, we have an agreement with Broad. So Broad actually does our license agreements, even though we partially own that technology. And the way Broad very thoughtfully licensed the CRISPR technology is with a set of very intricate, thoughtful provisions in license agreements. And of course, I'm going straight to the legal thinking, but that restricted what you could do with CRISPR technology, right? So very early on, you couldn't use it to make designer babies. Very early on, you couldn't use it to basically disrupt certain agriculture activities with seed genetics, especially in developing countries. I mean, I'm just naming a few. These were very lengthy, thoughtful provisions. And the licensing and the choice of commercial partners was made very strategically and very thoughtfully in terms of who is going to take this technology and commercialize it. Now, that was a really easy thing to do because CRISPR technology was covered by patent protection, right? And patent protection is easier to control than all of the different pieces that go into an AI system, whether it's the model, which is usually not patentable, and the data sets and the parameters and weights, et cetera. But I think there are bodies, and Chris, you may know about this, who are thinking about ways to thoughtfully license generative AI tools. I'm forgetting the names off the top of my head, but there are a few nonprofit organizations that are coming out with models for how to thoughtfully license this technology. So something really easy for a lab to think about would be, do we have a lab policy, like an internal lab policy, where we are thoughtful about under what license we release something on GitHub? Will it control downstream use? Maybe not, but it certainly signals. And I think MIT has such a loud voice and a powerful voice in the open source community that I think, the MIT license itself that everybody uses, is called the MIT license. We as lawyers often get squeamish because it's not like we licensed it to them. It's just, in fact, I'm sure that some of you even saw that DeepSeek said they had an MIT license. Well, they don't. They license things under the open source MIT license, right? So the point being is that we have a powerful voice, and I think we can be really thoughtful about how we proliferate technology.
Yeah, I think you've just answered the other question I was going to ask, which is, what's different at MIT than at other universities, right? In some ways, if you were in your job at any university in the United States, a research university in particular, you would be facing these things. But at MIT, with this longstanding commitment to the world of open and also this global reputation for it, whether it is through the publication of materials on open courseware, the open publishing license first initiated through the MIT libraries and adopted at thousands of universities around the world, and the MIT license, or so-called MIT license, that is a real gold standard for open source software. Does that make your job easier or harder?
Another really good question. I think it's a little bit of both. I mean, I think it's easier in the sense that we get to think the big thoughts, and when we talk, people listen to us. And I think we have a real opportunity to be forward-looking and sort of put out some thoughts about how we think things should be done, and I don't think that all universities have that. But on the flip side, we are in the news. We will be judged by historians in terms of what actions we took or didn't take. So I think it's really a mix.
Great. All right. Well, let's open things up to Q&A, and then again, as last time, I'll try to pass a mic to you, and if you're too far, I'll just repeat the question into the mic so people watching the recording can hear. So the floor is open. Yeah, go for it. Come on
up. I just want to say what they just shared is very, very useful, helpful. I just wonder if you are preparing your office, plan to prepare some document about like a AI guidance or something for the entire campus. That could be really helpful. I know it's not easy to be complete, especially because it's still developing, right? But it will be very, very, even some key points will be very, very helpful. You can share some points if you can.
Surely,
Thank you.
Surely. So, and can I ask too, what's your MIT?
I'm part of the MIT Office of Corporate Relations.
Oh, great.
Interacting with lots of
Excellent. Yes, I know your office well. Okay, thank you. So absolutely, the goal is to come out with guidance sort of for the three categories that I spoke about at the beginning. It won't come from my office per se. We try at MIT to keep the lawyer guidance to a minimum, but we will certainly be participating in preparing that guidance with a number of stakeholders on campus who really need to be involved. And I think that's what's making things slow. Believe it or not, I think MIT is ahead of the game in terms of a lot of this, but it's still hard to ensure that we've properly considered, which is really important, different perspectives from all over campus, and we have the right people in the room. Chris can attest to this. Sometimes when we don't have the right people in the room, we miss things and we need to backtrack a little bit. So we're trying to be careful. There is guidance, that first category about users of AI tools. There is some guidance, actually, oddly enough, on the IS&T website about responsible use of AI tools just in research or in other offices on campus. As researchers, you may find it interesting because it gives you the breakdown of what types of data MIT treats with different various levels of security. And so when you're using certain types of data, whether certain permissions are needed. But probably not so useful to all of you. I think it's a little bit more basic. The next two categories are a little bit harder. The second category, I hope there will be updates sort of about that research scaffolding soon, but I don't really know what the timeline is for that. The last category, there has been a new working group that has been tasked by the Vice President for Research. Chris and I will be participating on that working group. I hope I can say that.
Oh, you've caught me.
Publicly.
Yes.
I know, he can't say no now. But so I think that there will hopefully be some guidance coming out of that, which will be written, and that will be, very specific. For instance, researchers, giving them offices and actual administrators that they can go to for questions about how to permission and access certain data sets properly and in a timely manner, stuff like that. Some of these bigger questions around how do you ethically and responsibly think about sharing your technology and your research results, I think that will be a little bit trickier to put together holistic, comprehensive guidance.
All right. Other thoughts, questions?
A specific challenge that you think we could come up with a solution for that we don't yet have? Like, I feel like we're anticipating so much, and there's also already so much to respond to. You're put in an impossible position.
I
just repeat.
Yeah. So I was asked, can I pinpoint sort of a specific instance where there's something I guess we can do preventatively, is that right? To try to head off maybe some big risk, if I could reword that. Does that, okay. So I think I touched on this before with various licensing models. The same way that Chris was saying, and I totally agree with this, that we need to have new IP rules to cover generative AI and inputs and outputs and, copyright, et cetera. I think we're going to need to think through how we as research institutions think about sharing, right? I think that we want sharing and collaboration and openness always has to be a priority. But I think we're going to have to think about new ways to do it in a manner that bakes in this ethics component and responsibility component. And I would argue also maybe a little bit of sort of foresight and predictability component instead of simply not thinking about those things. But I think that requires some centralization of how we do things. And I don't know that we are close to that for many good reasons too.
Yeah, I think, another concept that's useful for thinking about this, and this came up in our conversation with Umair earlier, is what the Authors Guild calls, there are 3 C's, right? Consent, credit, and compensation. And what credit means in a kind of scholarly context is very different, right? Because of, as you mentioned it, these sort of questions of attribution, citation, replicability, those kind of core values of scholarly research, and not only in the sciences but across disciplines, are very much disrupted by generative AI models as they exist now, and that's I think an area where as a research community we'll be looking for guidance from MIT on how to do our work, but it would be great then also to share that and maybe model for other research communities best ways to kind of capture the spirit and values of academic citation and adapt them to the new technology.
I think that's absolutely right. And maybe this is just the lawyer in me, but the immediate response I have and we have to solve this, we have to figure out a way to manage this, is the simple misalignment between academic attribution, the 3 C's, the consent, credit, and compensation, although maybe compensation is less important for us, and the ability to access data and other research freely to advance your own research. So I think that's and as I was referencing before, you could be the same researcher and be of 2 minds. Bit.
Absolutely. All right. Question.
So the question actually that you already touched also is I wonder when you're thinking about all these issues and come up with some kind of guideline for the community, what kind of like a guiding principle that you will follow? I think you mentioned a lot about openness, and I wonder what other factors in terms of priority-wise, and how does it incorporate like MIT's historical like value into this kind of thinking? So that will be a question that I'd like to ask you clarity on that.
So first of all, I appreciate that question because I'd like to take a note to remember this for the working group, because I think that should be part of our first order of business, is to think about what are our priorities and list them, in terms of the values we want to be thinking about. My short answer is I don't know what MIT's position will be. I can tell you what personally I think makes sense, which is that openness, because first and foremost, we are a research and educational institution, and we want to pursue research for research's sake, right? Science for science sake. So openness for sure. I think autonomy and choice. I think we want to preserve our, the people who undertake that research and develop that scholarly work. I think we want to listen to, what they want to have done with their research. And then third, I think we want to be good we want to be good worldwide citizens, right? We need to think about how what we do affects the rest of the world. And I think it's not too far-fetched to say that in the world of generative AI, especially at a place like MIT, decisions we make or don't make can have worldwide consequences. So those would be the first priorities I would think about. I don't know, Chris, if you have something to add.
I think I would start with MIT's mission statement, which I don't know by heart, but I know how to find it on the website, and assume that whatever there is, whether it's formal or informal guidance or education, should be about advancing the mission. That's that's certainly square one where I think we would want to start. I think. Do we have maybe one more question? I'm cognizant that many of you are staring directly into the sunset and are having, depending on the afternoon, harder and harder time watching the session. I think we've had a really kind of amazing conversation. We've all actually learned a great deal of information, got answers to some questions, got questions in response to other questions, and know that in this rapidly advancing field that we will continue to explore in this area. But I'd like to thank Umair from our first session and Claire from the second session for making time for us today. And thank you all for coming, and carry on from here. Thank you.